Hello everyone, welcome to the webinar organized by Linda Liu and partners. Today I'm going to talk about the patent post-grant proceedings and its administrative litigations. Okay. I'm Peter Zhang and I'm a Chinese patent attorney and a partner of Linda Liu. I'm a former patent examiner and a former patent judge. I worked for the CNIPA for 11 years. Here's what I'm going to talk about today. There are four parts. Part 1, the basic information of patent invalidation in China. Part 2, the administrative phase of patent invalidation. Part 3, the litigation phase of patent invalidation. And the last part is the case where the invalidation decision being revoked, returning to the CNIPA for re-examination. Okay, here we go. Let's start from the part 1, the basic information of patent invalidation in China. This slide is mainly to show you some data of Chinese patent. This chart shows that in 2021, China granted more than 580,000 domestic invention patents, and more than 110 invention patent applications from overseas were granted. The number of patents granted to overseas applicants increased by 23%. From this slide, we know that between 2018 and 2020, approximately 72,000 patent infringement cases were accepted by the court in China. So, more and more domestic enterprises will exercise their patent rights. Because China has a dual-track system to handle the patent infringement and patentability challenge, in an infringement litigation before the court, if you want to invalidate the patent, you have to challenge the patent right before the patent re-examination and invalidation department of the CNIPA, which is short for PRED. So we can see that the number of patent invalidation cases has also increased. Let's look at the included decision to invalidation request. From 2019 to 2021, the number of concluded invalidation cases were increasing. So we can presume that the number of invalidation requests has also increased by about the same proportion. Please note that inventions, utility models, and designs are all called patent in China. So the concluded 5,448 patent invalidation cases include the three types of the patent. This slide shows that in the past 3 years, the concluded invalidation decisions for invention patents. You can see that in 2021, 1,071 invalidation requests for invention patent were concluded. Here's the share of three types of patent invalidated in 2021. We see that the largest invalidation proportion is utility model. The second is the design. The proportion of invention is relatively small. The number of inventions is about half of the utility models. The examination period of the invalidation request is usually 5 to 8 months from the filing date. So it's very fast, and the examiners in the period are quite busy. Last year, the number of patents being challenged by overseas applicants were 484. Among them, Japan ranks first, followed by the United States and Germany. It's the basic process of invalidation request. First of all, we need to file the invalidation request before the PRED. And as I said before, you cannot go to the court to challenge the patent, right? So, and you have to only go to the period. A decision about the validity of the patent will be made after the panel examination, including a hearing. If all parties are satisfied with the decision, the invalidation decision will take effect. If any party is not satisfied, it can appeal to the Beijing IP Court and the Court of the First Instance for the judgment made by the Beijing IP Court, which is either upholding the decision of a period or revoking it. If there's no appeal to the second instance, the judgment will take effect. In this case, if the period decision is revoked, the period must make a decision again through re-examination. If any party is dissatisfied with the judgment made by the Beijing IP Court, he can appeal to the IP Tribunal of the Supreme People's Court, the SPC. The SPC IP Tribunal will make a judgment to uphold or to revoke the period decision. Same as the first instance, if the period decision is revoked, the period must make a decision again. So what if any party is dissatisfied with the judgment of the IP tribunal of the SPC? You can request a retrial before the SPC. However, should the case be tried again, the SPC will consider for itself. Okay, part 2. Let's talk a little bit more about the invalidation proceedings in the period of the CNIPA. First of all, before filing a patent invalidation request, you need to do sufficient preparation. This means to collect and check the evidence. For the evidence obtained from outside China, outside the mainland China, it must be notarized and legalized. Then, in the case of a patentee, you have 1 month plus 15 days to amend the claims or make a response. The petitioner can submit a written rebuttal against the patentee's response. Normally, after receiving the patentee's response, the period will arrange an oral hearing. Unless the scope of the invalidation request is not clear, or the petitioner does not specify the reasons for the invalidation, or the reasons presented are not legal reasons for invalidation, or no important evidence is submitted, or the reasons and evidence submitted have been already considered in the previous round of invalidation decisions. This means poor preparation was done for the invalidation request. In this case, the invalidation request will be deemed to have not been filed or will not be accepted, and of course, there will not be oral hearing. If the petitioner fails to submit a receipt to the oral hearing notice issued by the period within the specified time and does not participate in the oral hearing, his request for invalidation shall be deemed to have been withdrawn. The oral hearing can be conducted in the absence of the patentee. The number of each party and its agents participating in the oral hearing shall not exceed 4. The oral hearing procedure is very important. The petitioner and the patentee will debate under the directive of the collegial panel and explain their reasons. After the oral hearing, both parties need to sign and confirm the record of the oral hearing to ensure the accuracy of the presentations. The collegial panel may allow both parties to submit additional statements within a specified time after the oral hearing, but new reasons and evidence cannot be added. Finally, a few months after the oral hearing, both parties will receive an invalidation decision. Regarding the process of invalidation proceedings, there are many questions. For example, someone may ask, when can I file an invalidation request? The answer is the invalidation request can be filed after the publication of the granted patent. So who can file the invalidation request? The answer is anyone, including the patentee himself. A request for invalidation can be filed in the name of the strawman. It's not required that the invalidation petitioner have an infringement dispute with the patentee. Are there any requirement on foreign petitioners? Petitioners from outside mainland China are required to provide identification documents, and I will discuss this later. So how long does the patent invalidation proceeding last? A decision will be issued in 6 to 8 months after the invalidation request is filed. For design, it will be about 4 to 6 months. So when can I withdraw a request for invalidation? The request for invalidation can be withdrawn anytime before the invalidation decision is made. And is it possible to investigate if someone has filed invalidation against a patent? The answer is it's not possible to investigate whether an invalidation request has been filed against a patent before announcement of the oral hearing. So we can check the announcement of the oral hearing for sure, but anything happened before the announcement of the oral hearing, we cannot know. So after the invalidation decision is made, we can check the invalidation decision and the notification issued by the PRID. But you cannot check the contents of the invalidation request and the response. So from this chart, you can see lack of inventiveness is the most common reason raised in the invalidation request. Although based on certain grounds, such as insufficient disclosure of the specification, lack of support for claims, lack of necessary technical features, and new matters, etc., the patent can also be invalidated. But the lack of novelty and inventiveness are the most common grounds for invalidating patents. Therefore, we recommend that when preparing to initiate an invalidation request, a prior art search should be conducted. Moreover, in the newly revised patent law, it stipulates that the application for patent and the exercise of patent right shall follow the principle of honesty and credibility. It shall not abuse patent right to the detriment of public interest or the legitimate right and interest of others. So this will be a new reason to invalidate patent. So according to the drafted examination guidelines, fabrication, forgery, plagiarism, pastiche, and other improper behavior in patent application process is a violation of paragraph 1 of Article 20 of the patent law. So I think this rules is designed for the so-called abnormal patent applications in China. The two main reasons to invalidate the designs are there's no significant difference between the design patent and the prior design, and the lack of novelty. Followed by the third common reason, the conflicts of the prior arts. The prior arts include copyright, trademarks, etc. So the evidence of the invalidation request is crucial. So let's talk about the requirement for evidence. First of all, if the evidence is a publication, then Its date of publication can be easily determined. The publication usually include patent documents, magazines, books, journals, technical manuals, newspapers, catalogs, product brochures, audio-video materials, etc. Regarding publications, notarization is required except for patent documents. And Chinese books, journals, magazines can be provided in original. The evidence can also be disclosure by use. There are multiple types and complex situations of disclosure by use, like product samples, physical evidence, witness testimonies, blueprints, sales contracts, receipts, etc. The date of the disclosure of use is difficult to determine, so we need a complete chain of evidence to determine the date of the disclosure. And notarization is usually required for the evidence of disclosure by use. The third is the experimental data, which are often used in the field of chemistry or life science. The experiment data can be data of the interested parties, data of the third parties, the appraisal opinion of the appraisal institution. There should be the official sale of the third party or appraisal institution, and the statement of the responsible person who did the experiment should be notarized. The fourth possible type of evidence is web page. You need to check if the publishing date is specified on the web page. Some websites are unable to access in China, so sometimes you have to do a notarization outside the mainland China. In general, a web page notarization or timestamps are required. The web page that have been deleted can be verified through libraries and Wayback Machine, etc. Here is an example of the experiment report. We can see the cover page of the report. There's a reference number and a seal over the edge of adjacent sheet. Here's the signature and official seal. We shall pay attention to extraterritorial evidence, the evidence that is gathered outside mainland China. According to the examination guidelines, extraterritorial evidence shall be notarized and legalized. Well, according to the provision of the Supreme Court on evidence in civil proceedings, no legalization is needed anymore. So that's a good news. However, in an unaffected draft revision of the examination guidelines, the requirement for legalization is deleted, but the guidelines are not effective now. So currently, you still need to legalize the evidence that will be used immediately. If it's too late to legalize, you may try to argue based on the provisions of the SPC. I think in the near future, legalization will be waived in the post-grant proceedings. Regarding to the supplementary invalidation grounds and evidence, the petitioner may supplement the evidence and add grounds for invalidation within 1 month from the date of filing of the request for the invalidation. If the patentee amends a claim in any way other than deletion, or if the patentee submits counter-evidence, the petitioner may add grounds and new evidence within the time limit provided by the collegial panel. Evidence of common knowledge, such as technical dictionaries, technical manuals, textbooks, may be submitted before and or during the oral hearing. The original notarial documents and evidence are checked during the oral hearing. So if you get very important, significant evidence and exceed the deadline of submission, what will you do? you can consider to file a separate request for invalidation. And the latter one will normally be heard jointly with the previous filed request. Alternatively, you can withdraw the previous invalidation request and file a new invalidation request. So patentee response and claim amendments. If you are patentee, you can choose not to respond because the patentee's response is not mandatory. Our general strategy is to submit a brief response first and a detailed opinion and the oral hearing or 2 days before the oral hearing. There are limitations to amend the claims during the post-grant proceedings. Recorded in the specification to the claims is not allowed. Amendment manner are deletion of technical solutions, further limitation on the claims, correction of the obvious error. The amendment timing should be the deletion of technical solution can be made at any time before the invalidation decision is made. Other amendment manners can only be made when responding to invalidation request or supplementing grounds for the invalidation. Here's an example of deletion of technical solution. You can see claim 1 containing component A or component B. So you can delete component A or component B through amendment. Please note deletions that cannot be made to delete specific groups of general formula in the Markush claim of the compound. Here's a further limitation on the claims. The example is like claim 1 containing A and featured by B. Claim 2 refers to claim 1 further featured by C and D. And then you can pick up C from claim 2 and add it to claim 1 to further limit claim 1. So there are some amendments that are not acceptable. 1. The title of the subject matter of a claim shall not be changed. The scope of protection shall not be expanded as compared with that of the granted patent. 3. The amendment shall not go beyond the scope of disclosure contained in the initial specification and claims. 4. Generally, the technical features not included in the granted claims shall not be added. And adding a new independent claim in the post-grant proceedings is not allowed. Okay, online hearing. Due to the pandemic, most of oral hearings are now done online, with the exception of a few instances involving extremely complicated evidence requiring on-site checking. Participating in the auditorium is permitted, but ID card and cell phone number must be provided in advance for the approval by the collegial panel. You can share the screen to demonstrate materials such as a PowerPoint. A party may participate with up to 4 agents. The collegial panel generally consists of 3 persons: the leading judge, the presenting judge, and the participating judge. The general process of oral hearing. So the panel will check the certificates of the parties and the power of attorneys, and to check the evidence and the opinion statements submitted by both parties. The petitioner can briefly state the ground for invalidation. Then the panel will investigate each ground. For each ground for invalidation, the petitioner will first explain and then the patentee will respond. The petitioner may then rebut and the patentee can also rebut again. All those are under the directives of the panel. The collegial panel may pose pertinent questions to both parties. When the collegial panel announces the conclusion of the oral hearing, parties shall wait to sign on the record of the hearing. And generally, the decision will not be announced in court, and a written decision invalidation will be issued within 1 to 2 months after the oral hearing. But in some simple case, most of them are about design invalidation. The decision will be announced at the end of the oral hearing, and the written decision will be issued afterwards. Okay, let's go to the part 3, the litigation phase of patent invalidation. So let's go to the court. The administrative litigation after the invalidation proceedings before the state IPA is a two-trial for final procedure. The first instance is in the Beijing IP court, and the second instance is the IP tribunal in the SPC. We can see that only 13% invalidation decisions were revoked by the Beijing IP court in the first instance. This means the invalidation proceedings before CNIPA is very crucial. In Beijing IP court, the debate revolves mainly around inventive steps. Okay, here is the basic process of the first instance. Let's check the requirement for the overseas entities. We can make a pre-registration before the Beijing IP court with a copy of the pleadings, power of attorney, and the original invalidation decision. Then within 3 months from the pre-registration, the plaintiff should submit notarized and legalized identification documents before the Beijing IP court. Then the Beijing IP court will send a notification of proof to the plaintiff, notifying to submit the evidence within a designated period, usually 20 to 30 days. The Beijing IP court will forward the plaintiff's pleadings and evidence to the defendant, notifying to submit the response and evidence within 15 days. Then the court will hold a hearing. If you serve as a third party, you can submit evidence within the designated period, usually 15 to 30 days, and third-party observation can be submitted at the list before the oral hearing in the court. The court has different requirements for the plaintiffs in different countries. Let's take Germany for example. A certified copy of the business register certified by the district court is required. The document will contain the company name, registered office, branch agent rules, governing body, senior management, authorized representatives, and other information. The copy of the business register should clarify the requirement for the signature power of the company and its branches to issue power of attorney in different circumstances. In the representative rules, it will be clarified that what rules can represent the company. For example, the company is represented by some director members of the board, or the members of the board and authorized representatives. As to the list of members of the board and authorized representatives, they should be shown in the list of the governing body, executives, or the authorized representatives. Here is an example of Germany. It's a coverage of the certified copy of the business register. And Beijing IP court has different requirements for different states in the United States. Take California, for example. The requirement documents include the certificate of status issued by the Office of the Secretary of State, the restated articles of incorporation certified by the Office of the Secretary of the State, the statement of information certified by the Office of Secretary of State. Here's the example of the State of California Secretary of State. Okay, this slide shows the online trial of the first instance. Due to the pandemic, all trials of administrative litigation cases often have you can share the screen to demonstrate materials such as PowerPoint to the judges. Each party may send up to two attorneys. The bench is generally composed of one judge and two jurors. The auditorium is not open due to the limited number of ports. However, you can observe an online trial by logging on the China Open Court website here. For some cases, video replay is available. The judgment is usually made within 2 to 6 months after the hearing. Let's go to the second instance. The second instance is held or tried in the IP tribunal of the SPC. The IP tribunal was officially established on January 1st, 2019 to hear IP appeal cases with a high degree of technical expertise. The SPC IP tribunal received 670 administrative second instance cases in 2020. The SPC IP tribunal concluded 494 administrative second instance cases in 2020. Only 8% of them was remanded for retrial or overruled. So the percentage is quite low. Let's check the basic process of the second instance. The foreign appellant can file a request for appeal to the Beijing IP court. When finishing the payment, the case can be transferred to the IP tribunal of the SPC within 1 to 6 months. Then IP tribunal will issue the notification of acceptance of the second instance and a notification to provide the proof. The appellant should submit evidence within the designated period, usually 10 to 20 days. Then the IP tribunal will forward the petition and evidence to the appellee. The appellee can submit response and evidence. Then the IP tribunal will hold a court hearing. The IP tribunal of the SPC mainly holds on-site court hearings, and only a few cases are heard online. Each party may participate with up to 2 attorneys. The bench is usually composed of 3 judges, and only a few cases are heard by only 1 judge at the court hearing. Participation in the auditorium is possible for on-site hearing. There's an online trial app that supports cloud courtroom, but it does not support screen sharing, and there's no PC-based software yet. Participation in the auditorium is impossible for online hearing. I think this is because it's difficult to identify the observer. And the second instance judgment is usually made 1 to 6 months after the court hearing. So, if any party is not satisfied with the judgment of the second instance, he can also consider to request the SPC to retrial. Petition for retrial should be made within 6 months after the judgment, ruling or mediation take effect. For a retrial petition, the SPC will review the necessity and issue a ruling. Before a ruling is issued, a hearing is usually held in writing, and in some cases, especially some very important cases, interviews are organized with the parties. Most of retrial petitions will be denied. The SPC will make a retrial judgment in circumstances where a retrial is conducted. Okay, last part. What will be following up if the invalidation decision of PRID is revoked by the court? Generally speaking, when invalidation decision being revoked, the PRID should set up a new collegial panel to make a decision again, with or without oral hearing. the invalidation decision cannot be contradicted to the prior effective judgment. The collegial panel decides what kind of re-examination to conduct according to the actual situation. For example, if the judgment shows that the decision that the patent should be invalidated is not established, the collegial panel shall re-examine the other grounds for invalidation in the original invalidation request. If the judgment shows that Claim 1 is invalidated, the collegial panel shall re-examine the validity of other claims. In the case where a retrial is filed by the CNIPA, the re-examination will be delayed. In the case where the CNIPA does not file a retrial petition but a party files, the party may request for a suspension of re-examination. Invalidation request can be withdrawn before the invalidation decision is made. And last, if unsatisfied with the invalidation decision, another lawsuit can be filed. Okay, that's it. That's all for today's presentation. If you have any questions about the post-grant proceedings in China, you can let me know. Or you can send the questions to me to the email address office@lindapatent.com. Thank you for your attention. I'm Peter Zhang. See you next time.